Hey friends, I'm streaming live. Today is September 7th, Monday, September 7th, which is Labor Day. Happy Labor Day for those of you who are here in the United States. I'm waiting for my system to tell me that you guys are able to see me. In this session, guys, we're going to talk about the preliminary injunction order that was issued, the lawsuit with respect to the presidential proclamation and the fact that the plaintiffs were seeking a preliminary injunction. Well, the judge issued his order on Friday, September 4th. Okay, now I see that you're with me. Good to see you guys. Hello. Nice to see you. See, Doja, nice to have you on with me. How are you guys doing today? How are you feeling? Happy Labor Day, not 4th. Happy Labor Day. Jerry, it's nice to see you. Thank you for joining me. Who else is on? Nadia is on. Hey, Nadia, it's good to see you as usual. Rashida, great to see you as usual. Thank you for that. Sandy, nice to see you. Kerwin, great to see you as usual. Who else is on? Christine. Okay, so it's Labor Day, right? And I shouldn't be working, but I am. You guys can tell I'm really I work a lot. Let's go ahead and dive into this judge's order because it's very important. And many of you may have already heard the news that the judge did issue his order on Friday, but it's a very long order. It's 85 pages. And so I had time to finally read it, and I want to go over some of the major points with you guys. Okay. It's good to see you, Eric. Thank you for joining today. Marlon, nice to have you on as well. And friends, I have good news and I have bad news. So I just want to make it clear that this is one of those videos that's or sessions that's not really that easy to pull off because some of the news is not going to be great. All right, it's good for others, but not for the most part. It's bad news from my perspective. Okay, let's go ahead and dive in. And as you're coming on board, join in this session, just give me some likes and thumbs up and announce yourself and let me know where you're watching from. For those of you who are new to me, welcome. I'm Latoya McBean Pompey, an immigration lawyer based in New York, but we work with people all over the world. And I've been tracking the issues with respect to the presidential proclamations that are preventing so many people from coming to the United States to be with their family or to start work. And the biggest update with respect to this issue is the fact that on Friday, September 5th, Judge Mehta issued his order, and it's 85 pages long. And I have some notes here. I'm not going to take you into everything that's in this order. It's not necessary to dive into all of the legal arguments. I'm just going to pull out some main things here that I think is very important for you guys to understand. Now let's do this. Let me go ahead so this is the order. It was issued on September 4th. And just to refresh your memory, guys, who do these presidential proclamations impact right now? They impact those who are in a family-based preference category. So we're talking about parents we're talking about spouse, children of green card holders. We're talking about adult children of U.S. citizens. We're talking about siblings. And then we're also talking additionally about other people who this impact. We're talking about diversity lottery winners, the H-1B, H-2B, J trainees, teachers, au pairs, and some others, non-immigrant visa applicants as well. Now, the proclamations, as you guys know, suspended the issuance of visa to these individuals, and it also suspended their entry into the United States. And so with respect to the proclamation, the plaintiffs, the Gomez plaintiffs, wanted a preliminary injunction to stop the enforcement of these policies, right? And so so here's what happened. Unfortunately, the preliminary injunction, guys, was not issued with respect to those who are in the family-based preference system. It was only issued to the DV lottery winners. And so the court found that the DV, the diversity visa winners, right, the lottery winners, they would suffer irreparable harm if they don't get that visa issued by September 30th, this month. And so those are the individuals who the court found had a more compelling argument and a more compelling case. Everyone else, the argument with respect to those who are in the family system, the H-1B, the H-2B, J visa applicants, the court did not agree with the plaintiff's arguments. Okay, so that is the biggest thing that you should know about right now. And so let's do this. Let me see what else I could share with you here based on my notes. So the DV lottery winners, there were about 43,000 people who had not yet been issued their visa before the proclamation, the April proclamation went into effect. And so according to the court, those individuals, the embassies should not interpret the proclamations to mean that DV lottery winners cannot get their visa issued. So those individuals, the court said that the embassies need to expedite the processing of visas for these individuals this month. The court did not say that they would give the government more time to do this beyond the September 30th deadline. But they did say that we will revisit this issue, come back to us in a couple of weeks, let us know how many people have been processed at this point, and we'll revisit the issue about whether we should extend this deadline to give people more time, to give the embassies more time to process these individuals so that they would not be harmed by not getting their visa issued and their opportunity to come to America. And so that's the biggest takeaway from the judge's order. Again, it is 85 pages long, right? This thing is huge, 85 pages long. And let me just read to you a summary here on page 4. It's going to sound very, it's all legalese, right? Written by very smart people. So just bear with me here, but I want you to understand exactly what the court said. And let's see, page 4. Okay, so let me pull this up a little bit better for you here. Okay, so the court rejects plaintiffs' statutory and constitutional challenges to the proclamations, but holds that plaintiffs are substantially likely to succeed on their claims that the State Department's policy of not reviewing and adjudicating non-exempt visas is in accordance with law. Well, let me back up. Firstly, the court said that they're granting this request in part and denying it in part, okay, as it relates to the preliminary injunction. And so then it says, it holds that plaintiffs are substantially likely to succeed on their claims that the State Department's policy of not reviewing and adjudicating non-exempt visas is not in accordance with law, is in excess of statutory authority, and is arbitrary and capricious. Okay? It also says the State Department's non-processing of 2020 diversity visa applications constitutes agency action unreasonably delayed, and the State Department's exclusion of 2020 diversity visa applications from its guidance on mission critical services is arbitrary and capricious. I'm not going to read the rest of this. I'll put a link in the description below so that you guys can go back if you'd like. You could go back and read the entire 85 pages for yourself so that you could see the arguments that were raised. But in a nutshell, the 2020 diversity visa folks will face irreparable harm if the injunction is not issued. So the judge has held. Now, one thing you guys got to remember is that this judge was appointed by President Obama, right? And so you know, obviously you would think that, okay, he's going to be on the side of immigrants. He's maybe more on the liberal side, right? But if you read this order, the court had a lot of very strong arguments siding actually with the government, the Trump administration. And so that's unfortunate, but that's where this is right now. So again, the court temporarily stops the no visa policy as it's applied to the DV 2020 winners and the beneficiaries. So that's great news for them, and that and embassies should expedite processing and issuing diversity winner visas by September 30th. As it relates to the families who are waiting for an interview, waiting for a visa, waiting to come to America, the court did not stop the enforcement of the proclamation. So all of those individuals are still impacted here, unfortunately. So that's good news and bad news, right? So let me pause for a moment and take a look at some of your comments before we wrap up. Okay, so Sophia says, what about children under 21 of green card holders? So Sophia, for children who are under 21, they are also largely banned under the proclamation unless they are going to age out during the period of the proclamation. So if they're closer to turning 21 over the next few months, while the proclamation is in effect, then those individuals are exempt and they are able to come in. Okay. Okay. Danette says, what about children under 21 of U.S. citizens? So they are actually not in the family preference system. They are immediate relatives of U.S. citizens, and so they are not banned under this proclamation. Someone has asked a question about the F4. Nahid, yeah, F4, that's the sibling category. So that category is also banned under this proclamation. Guys, I do encourage you to go back and watch some of the older videos that I do have explaining who is caught up in these proclamations so that you have a good sense of where your family member sits at this point. The point of this video is to share with you the judge's order because plaintiffs were attempting to get a preliminary injunction that would stop the enforcement and implementation of these awful proclamations. But they were successful with respect to the DV winners, but not so with the family categories. Okay, so that's kind of unfortunate. Claire, that is unfortunate, not kind of. It is unfortunate. Let me be clear about that. Clara says, what about marriage-based interviews for those who are already in the U.S.? I think I had mentioned in my last video on Thursday, I'm not sure if I did not, but those who are here in the United States are not impacted, number one, by these proclamations. And so interviews that were scheduled but canceled due to coronavirus, field offices have been sending out notices to those individuals. I don't know which field office you're in. Some are moving a bit faster than others. Others, all field offices have new procedures now with respect to how they're conducting interviews and doing the work that they typically would do due to COVID. And so, Clara, the proclamation is not impacting the marriage-based interview schedule here in the U.S. It's more about what's going on at that local field office and what phase of reopening or where they are with rescheduling and scheduling interviews. They are scheduling interviews, okay? They are scheduling interviews. Okay. I'm getting a lot of questions about the F4 category, and yeah, that's part of the proclamation, the sibling category. Rock is asking about what about the VAWA, domestic violence? That's not relevant to the proclamation. The proclamations have absolutely nothing to do with this. The proclamations impact those who are outside of the United States trying to get a visa to come into the United States. Okay, so I'll link to those older videos here so that you could get a good sense of what's going on. Okay, so again, guys, in essence, DV winners, just so you know, 12,000 people were issued, DV winners were issued their visa before the proclamation went into effect in April, but 43,000 had not been issued their visa. Those individuals are now able to obtain their visa. But one thing you should know as well, DV winners, is that the judge's order says, although the embassies and State Department can't interpret the presidential proclamations to prohibit the issuance of visas to DV winners, the order doesn't prevent the embassies from prioritizing how they're processing and adjudicating all of the different types of visa applications, and it's all going to be based on what that local embassy determines what they could handle, meaning their resources. What's going on with their resources, country conditions, what's happening with COVID-19 in that country. The embassies still have the ability to prioritize their caseload based on all of those other external factors. And so you should know that as well. So the court did not go as far as saying, well, you guys got to prioritize the DV winners, regardless of your resources, regardless of country conditions, regardless of what's going on there with COVID. No, the court did not go that far. So just keep that in mind, that the embassies still have that ability to determine how they are prioritizing people or applications. All right. Okay, so I think that's pretty much all that I want to share with you in this one. The proclamations are in effect until December 31st of this year. And the government, if President Trump is reelected, the government has basically reserved the right to extend the proclamation as applied to all of those individuals who are in the proclamation. Family-based preference category individuals, H-1B, H-2B, J, some J visas, and the L visa. Okay, so guys, please share this video with others if you enjoy these sessions and find the information that I'm sharing valuable. Follow me on Instagram to stay in the loop with what I'm working on and sharing with you. Subscribe, like, comment, share the videos with other people. Stay plugged in. Hit the notification bell. Guys, do it all. Do it all, because you don't want to miss anything. So thank you so much for being part of this community. And I hope you guys get some rest today. All right. Take care. Bye-bye.